The reason we create a revocable living trust is to transfer our assets into the trust so they're protected from probate. So it's natural to think that cars, because cars have titles, should also go inside the trust. In this video, I want to show you the unexpected negative consequences of putting your car in a trust and what other options might be easier and better for you. Transferring the title of a car into a living trust is an administrative hassle. It's as much work as selling a car to a third party. You're standing in line at the DMV, filling up all those paperwork. And on top of that, the DMV might impose a transfer tax. Usually, when a car transfers from one family member to another, the tax is waived. But transferring to a living trust, that's kind of a gray area. You might be able to talk your way out of getting tax, or you may not. Next, you'll have to inform the insurance companies about it. Insurance companies are notoriously not very flexible, not very trust savvy. They don't know what to do when the policyholder is not a living human being, but an entity like a trust. So they may increase your premium, or at worst, they could cancel your policy. But all those is not as bad as this next one, okay? Putting your car inside a trust could potentially invite lawsuits. Let me give you an example. Say you're in a car accident and you're at fault. If the other party finds out that the car is owned by a trust, they think dollar signs, dollar signs. They think deep pockets. So when initially they would have just settled, now they're thinking lawsuits. So you see, there are a lot of downsides to putting your car inside a trust. And when you think about it, your main goal is really to ensure a smooth transfer of the car upon your death and to avoid probate. So are there easier alternatives to achieve that? Okay, option number one is the easiest: transfer on death deeds. It's like beneficiary designations. You specify a specific named beneficiary on your transfer on death deeds, and upon death, it transfers smoothly to the beneficiary. Unfortunately, it's only available in certain states. You can pause the video and see if your state is on this page. The second option, if your state does not offer transfer on death deeds, is to add your heir, your child, your niece, whoever you want this car to transfer to, add the person as a joint owner with rights of survivorship. It's not my favorite option because I lose full control when I'm alive. My favorite combination of an estate planning strategy is if I have full control while I'm alive and I skip probate at death. In this option, I am exposed if my joint owner is in a car accident and it's her fault. But fortunately, the exposure is just the car. It's not going to affect my personal property, my house, or my business. So it might be a risk I want to take. If you want to go this route, there are three things that I want you to pay attention to. One is that on the title form, you want to look for a box that says joint tenants with rights of survivorship, and make sure you check off that box. And put your names, your name and the person, the joint owner's name, using an or. Because in legal parlance, when you say John or Mary, then either John has full control or Mary has full control. As opposed to if you use the word and. When you say John and Mary, legally, it means that you need both of them. You need both John and Mary to make decisions on the car. So by definition, you may lose the automatic survivorship. And the third thing I want to point out is that in many states, the sales tax, the transfer tax is waived if you're adding a family member to the title. Now I'm going into the options after death. This means you did not do a transfer on death deed either because you forgot or because your state doesn't allow it, and you did not add anyone as a joint owner to your car. If you did not do any of those things, and then upon death, you still have two other options. One is to use a family affidavit, and the other is to file for a small estate probate. This affidavit is quite a simple form to fill up, and you can easily obtain them from your local DMV or probate court. It's not a scary form at all. It is just some instructions here. And here is where you declare that, yes, the person has passed away. And here is the property that you are trying to transfer. And you list all the heirs, as I mentioned, because you have to make sure that either you're the sole heir or all the other heirs are in agreement that your father or your mother has promised you this car. And then the signature section. It's one page, simple. You don't need an attorney, but I do want to stress that it has to be notarized, and you are signing something that will incur the penalty of perjury if you're not truthful. So if there are heirs, don't be cute and not list them to simplify matters. If you're a spouse, there is a special affidavit usually for surviving spouses. In fact, it's so easy that a lot of times you can just call your insurance company and they will transfer the automobile to the surviving spouse. If you're not a surviving spouse, then you might have to go through this paperwork, but you saw how simple the form is. The last point I want to make, which is actually the most important point, is that no matter which option you use, you want to specify your wish for your car in your will. This could either be your last will and testament, or if you have a living trust, it could be in your pour over will. But you want to be very specific with a very simple sentence. I give the name, model of the car, and the VIN number to my son, and you specifically name your son if he survives me, because this will help facilitate the process, no matter which of these 4 options you use. Instead of an affidavit, some states, like my state, Massachusetts, offers a small estate probate to take care of small assets like a personal car. I do a deeper dive on small estate probate in this video right here. You'll see that it is not anywhere close as scary as a full probate at all. It is quicker, easier, and cheaper because it usually does not involve an attorney.